So you guys probably have this to get started, or at least you saw this online. So we're going to cover basically how to begin working with probates and trusts, how to get certified as a probate specialist, and meeting with attorneys and fiduciaries. These are attorneys. Fiduciaries don't look like this. Okay. Why trusts are critical to any homeowner, and these guys can explain that. And then the difference between trusts and probates, and then standard transactions. The differences, by the way, have become fewer as time's gone on because of disclosure requirements. So can you guys all hear me okay? Okay, sounds good. So basically, I like walking around. How many of you got your license after 2017? Anybody in here? A couple of you. Okay, so you had to go through orientation, so you probably saw me here anyway. So anyway, trusts and probates, I started to do this in the 1990s. And it was different back then because, oddly enough, there wasn't any internet, okay? So I had a friend of mine who was best friends with the county clerk, and he was able to go into the basement where the probate records were kept. And the rule is you could check out one. And probate files are pretty thick. But he got to have a basket. He got to check out whatever he wanted. So he'd get 20 at a time, and he'd write everything all down. Then he'd go back and he'd go into his computer and he would put all the information of the probates. And the most important information was, does the probate estate have any property in it? All right. Because if it doesn't, do we want to think about it? No, sorry. We're sorry the person passed away, but no. So we wanted that information. We wanted to know who was confirmed by the court as the administrator or executor. And I also wanted to know who was the attorney handling the probate. So I'd get all that information, my trusty floppy disk, and I'd plug it in and I'd do a mail merge, and I started mailing these things out. And back then it wasn't, well, let's just say I mailed out what by today's standards would be considered somewhat prehistoric. But I started listing 8 or 9 or 10 properties a year doing that. And these were virtually all probates. And oddly enough, the majority of them were for administrators that weren't even remotely, they weren't even in California. And as time goes on, I'm thinking, well, this is working out okay. Another thing we didn't have back then is we didn't have a probate designation. There weren't any probate classes back then. All right. CAR didn't have one. NAR didn't have one. So I thought to myself, I better figure out what goes on in a probate transaction, right? So you can't even make this stuff up. My brother-in-law, who lives in Ecuador, we're chatting back and forth. He's going, hey, my brother wrote the book on probate. I'm going, no, he didn't. He goes, no, seriously, he wrote a book on probate. I'll have him send it to you. Well, he did. It was about this thick. It was yellow, and I read it. And it had everything in there I needed to know. Pretty much. So anyway, that's how I got started on this. And then as time goes on, you realize, wow, this is interesting. The light bulb went off. It's like, well, every one of these probates has an attorney involved. And these attorneys are specialists. They are trust and probate estate specialists, usually certified by the state. So guess what? That's their area of practice. So I thought, why am I sending to just the administrators? Why don't I focus on the attorneys? So I started working with attorneys and becoming friends with them, such as Adam and Deborah here. Adam owns a law firm, Ferguson Law, right over here on the Alameda. Deborah's an associate attorney there. And I began establishing relationships with attorneys. And turns out they're cool. And my marketing turned into, it went from doing what I was doing to sending out different things to eventually sending, email and using the internet to now basically what do? We go to lunch a lot, but you enhance the relationship. And so over the years, because we've been working together since before Paul Pelosi, sadly, I've been doing this so long, several attorneys I've worked with have passed away. True. About 15 years or so, and Deborah and Adam are handling my wife's mother's estate, so this is something that you're all going to go through it at some point in your life. But as real estate professionals, it's something that if you put your mind to it, and if you are willing to learn about it and get things moving in the right direction and pay your dues, learn what you got to learn, and do everything correctly, and listen to the attorneys unless they're wrong, which is very infrequent. No, seriously, it's weird, is it not? Some things happen that are not exactly, it's like, wow, how did that happen? And we'll tell you about a couple of stories. But the point is that you can do some business in this realm. And there's a flyer that I left out there too, and it has two of the designations that you can get. Well, two places to get a designation. The designation I have is CPRES, which is Certified Probate Real Estate Specialist. Now, I only got that, I don't know, not that many years ago. And all I did was take the test because clearly I had done these for so many decades that I actually could just pass the test. But it's a good thing to do if you want to learn about probates and trusts and things of that nature, because we'll talk a little bit further about that as we get into this. So now what I'll do is I'll turn it over to Adam and Deborah, and they can tell you, one will tell you about probates, the other will tell you about trusts. And in addition to being able to answer your questions here, their information is going to be important to you, because anytime you sell a property, that buyer, they really need to title that property in a trust, because if they don't put it in a trust and somebody dies, it's going to be probated. And probating a property, it's great for the attorneys. They make a bunch more money on a probate than they do writing a trust. When I say a bunch more, I mean a factor of 10, 15, depending on the size of the estate, right? And trust can be handled pretty quickly, reasonably quickly. Probates, what's the longest one you've ever had, Adam? Or is it still going on? Yeah. Did you hear what he said? It can take that long. There's a guy by the name of Howard Hughes that died without a will, or no, he had one, but wait, was it real? We don't know. Anyway, that you can see what's going on there. So you want to talk about probates? All right.
All right. Howard Hughes, by the way, 31 years in probate before it was finally settled. Yeah. Okay. So let me talk a little bit about the probate and trusts, just so you have an overview for those of you who haven't experienced it. I expect most of us have had a little bit of contact, at least, even in our own lives, with either probate or trust administration. But probate is the process by which we administer an estate of a decedent after they die, and we pass their assets. We pull their assets together, we pay all of the debts of the decedent, and then we distribute those assets out. And part of that, of course, is liquidating a house or determining where it's going to go. So probate happens if a person dies without a will, called intestacy, or if they die with only a will and no trust. So when we go through the probate process, what we do is we contact the court in the county where the assets are located or where our administrator is administering the estate. And we ask the judge to open probate. And opening probate, if they had a will, involves lodging the will with the court and waiting for the court to appoint our client the administrator of that estate. So I just want to back up just a little bit, because I often get calls from realtors who are anxious to sell a property on an estate, and they'll call and say something like, my client is trustee and we want to sell this property. And I'm like, great, I'd love to help you. We need to administer this trust. So send me a copy of the trust. Oh, they don't have a trust. So one of the things to get down is, what are the terms that we use? So a trustee is the fiduciary of a trust, and that's the person who will have authority to sell real property. In a probate estate, it depends on whether they had a will or not. If they had a will, and the person named in the will as the executor is appointed, they're called an executor. If they did not have a will, the person who gets appointed is called the administrator. And if they did have a will, but maybe the person they named as executor can't serve, then that person who gets appointed is called an administrator with will annexed. So you need to make sure that you know that you're working with the person who actually has the authority to sell the property. It takes some time depending on which county we're in. Some counties are pretty quick once I file the probate paperwork to get to the hearing and appoint the administrator. Some counties take a very long time. Up until recently, Santa Clara County was taking 4 months from the date that I filed the paperwork to the hearing date. So in those 4 months, we can't sell the property because we don't have somebody with authority to sell the property yet. It's getting shortened. I just got 9 weeks on when I filed last week, so 9 weeks out for the hearing. So it depends on which county we're in. Some counties are much quicker than that. Do you want to? Yeah.
Thanks, Deb.
Please go to the microphone if you have a question. That way the people on Zoom will actually hear the question. And in the recording, if you get it later, you'll hear the question too.
So if an estate is valued at less than 182,000 or 186,500, I think it is right now, each year it goes up by a little bit. If the whole value of the probate estate property, and not all property is necessarily going to be probate estate property, but if it's all under 186,000, we can do a small estate affidavit. Clearly that won't be an estate that has real estate in it. So an estate with real estate is going to have to go through probate in California.
I have another quick question. I was in another training recently where we were told by the instructor that if somebody dies, debts like maybe they have an IRS debt is uncollectible. Do you know anything about that?
I suspect they were referring to a joint tenancy deed. Otherwise, debts are absolutely collectible against the decedent's estate. There's some rules and there's some limitations. I wouldn't worry about those for, your role here. Simply rely on an attorney in that scenario. But by way of introduction, I'm Adam Ferguson. Deborah Casara just spoke. Thank you for having us. We are Ferguson Law Group, and I've been doing this since 2007, 16 years, 17 years, something like that. Met Rick through a former partner of mine, Paul Pelosi, and ended up in the world of probate for probably the same reasons you guys have, which is there's a lot of business here. So I went to law school to be a sports agent. Probate's not really sexy. But I interned for a law firm that did trust and estates. And I read this article about this massive transfer of wealth that was going to occur with the baby boomers. And it was going to be the largest single event in the history of the world. And there was going to be a lot of business. And we're there now. It's happening right now. Everybody that I know and work with in this industry is so busy, we can't even refer to the people we normally work with because everybody has too much work. So it's a fabulous problem to have. You're in the right place if you want to grow your business. And the way to do that is to get in with the attorneys and to get in with the private fiduciaries, which I don't know if any of you know what that is, but it's people who are fiduciaries, like Deb said, trustees, administrators, executors for a living. So they're very good at what they do. They tend to come into messy cases where the family members can't get along. And so we tend to work with them quite a bit. We do litigation and we're not scared of that stuff. And so Rick has been a fabulous resource for us, but his ability to work with us and our ability to rely on him is contingent on him knowing what he's doing. And so you guys really need to learn the ins and outs because that's a huge value to any attorney you're working with. All right. Show of hands, how many people have actually done a sale through probate? All right, pretty good.
The buyer or the seller?
Great question.
The buyer or the seller? How many of you represented sellers? Okay.
That's where all the work's at, right? Buyers agents don't do anything in probates, relatively speaking. Although you can get aced out. I don't know if that's happened to anybody here as a buyer's agent. If a court has to approve a sale through an auction process, you can go through all the work. You have a contract and your buyer's not getting the property if somebody outbids them. So I'll let Deb go through some of the nuts and bolts there of an actual probate sale because it's not the same as your average sale. But as she explains that, I think it'll really enlighten you guys as the agents as to why you want your clients to have trusts, right? Separate and apart from you personally or your family personally, just selfishly as an agent. Trust me when I say you would much rather have a client selling a property as a trustee than a client selling through probate. Okay, probate just tends to be clunky, slow, administratively exhausting, and there's many steps that are in addition to your average sale. Deb, you want to walk them through just a few of the steps of how we do the actual sales?
Sure. So when you are working with your client and they are either executor, administrator, some form of personal representative, they will be given a certain level of authority by the court based on what the will says, or if there is no will, kind of what their wherewithal is in the court. And so they will be given authority under IAEA, right? That's what we hope for when we get a client appointed as fiduciary. We want them to have full authority under the IAEA, which is the Independent
Administration of Estates Act.
Yeah, Independent Administration of Estates Act. Thank you. So if they have full authority, there are a lot of steps that we can kind of skip through without having to get court approval. And one of those is to sign a contract with you to list the property. You may or may not know that your client only has the ability to bind that contract for a certain amount of time. I think it's 90 days. 90 days.
Not 2 months, 90 days.
90 days. And that
Probate listing that's longer than that, you've got problems. Someone does not know what they're doing.
right? So you need to renew that contract with the client every 90 days, or it will, any sale that you make will not necessarily be a valid sale.
90
90 days.
calendar
90 calendar days. 90 calendar days. Okay, so once your client has the authority to sell, we begin working with the client and the realtor on what is needed to prepare the property for sale. And this is, I can tell you, a place where many realtors drop the ball in communicating with the attorney. So you need to communicate with the attorney what is going to be done. Is this going to be an as-is sale? Are there proposed corrections to the house, right? Are we putting a new carpet? Are we painting? Are we having to put a new roof on? All of those have expenses associated with them, and we need to notify the heirs at law about the expenses that you're intending to make on behalf of the estate. So if we want to fix the roof and carpet and paint, you need to give an estimate to the attorney in the form of what's called a notice of proposed action. So I often send out a minimally filled out notice of proposed action to the realtor. And what I'm expecting back from them is a list of what they're going to be doing, what the expected costs are for that, what the listing price of the property will be. I'll slow down. I see many of you writing. So I need the listing price of the property, the minimum that the fiduciary is willing to accept once bids come in, and then, of course, what those expected expenses are. I need all of that information before I can send out the notice of proposed action, which goes to all of the heirs at law and anybody named in the will that would be a beneficiary. I send it out to them. If we're in the probate realm, they have 15 days to object to the proposed actions that I'm going to take in preparing the property for sale. So if the realtor sends it back to me and I've only got a couple of those things, we waste many days trying to pull teeth to get that information out that I need. So get that information as quickly as you can. You need to work with your client to figure that out. Sometimes the client will ask me, well, what should the minimum be that I accept? I have no idea. That's your job. And I love that you guys do it so well, but I don't know. I don't know real estate. So I'm just waiting for those numbers to come back. So once they're back and we get the property listed and ready for sale, it's great if you are like Rick and keep the attorney informed all along the process, because beneficiaries can begin to squawk and heirs at law can begin to squawk, and they squawk about the craziest stuff. I know we all have war stories about somebody who raised a head and objection at times we didn't expect it, and those all need to be addressed. And if we can nip them in the bud, we can get through the process much more smoothly and get the house sold. But if not, we end up in crazy litigation, which is never fun.
As an example, we just closed a transaction in San Mateo where we had a couple of brothers, and we sold the initial house. And this is stuff that happens, just so you know what's going on. Families are weird, okay? The initial house where one brother lived, was owned by the parents. And this brother moved in and lived there. The parents said, they're both gone. And he lived there for over 10 years, correct? So they said, well, now we're ready to sell this house. Let's go and take a look at it. Now I have a concierge program. I'm able to go in there and bring my contractors through and put houses in good condition. You know, basically you do the fixer upper like you see on TV. You do this for them and you get paid at close of escrow and it enhances the value. You put in 50 grand and maybe you sell it for $150,000 more. That's all great. This particular house, we could not do that. The house was trashed beyond belief. We would have had to have started by replacing the roof and all the ceiling sheetrock, which had fallen through because of the roof leak. Then we would have had to rebuild the house. Well, you know, that scenario, especially court ordered, did not feel right. So we sold it as is. He moved on and lucky him, he got to buy a brand new house and he moved out. That was great. Fast forward another year or so later and the other house is going to be sold where the other brother lived, but that was grandma's house. Okay. And grandma's house was very old, I think built in 1937. Everything looked good. Everything was fine. Put out the notice of proposed action. Everything was fine, except the brother then all of a sudden, after signing off on all this, now had a problem. This is the brother that ironically completely trashed the other property, reducing its value by at least $250,000. And he got so crazy that I had to meet with him and walk through the property that we were about to sell. And his big concern was, and this is what you deal with, his big concern, well, you know, this electrical in this house is too old. So he writes Adam and I an email and says, well, I think what we need to do before we sell that, by the way, NPA had been sent out, everybody approved, house is ready for the market. All we're waiting for is photos. Got it? He says, well, no, I think we need to rewire the property. I think we need to put in a whole new electrical system. You know, I'm just not comfortable with this. He didn't get the fact that we had it inspected and we disclose all of this. He didn't understand that knob and tube wiring, while not ideal, still functions and is disclosable. Do you think we're going to sell a property to a buyer and tell them, no, the electrical's fine? No, we say, you want to do an inspection, do an inspection. But, oh, by the way, we had an electrical inspection. Here is a copy of it. Here are all of the photos of what they found. So you know what you're buying, Mr. Buyer. So I spent 2 hours with this individual walking through the property. He was finding little things that it's just, I'm bringing this up because when you're dealing with a family issue like selling property, these are the kinds of things that come up. Now, this was a fairly minor one based on our history. We've had others. So we got the property sold. Everything was fine. It closed escrow. Everything was great. But that's what happens. That's why the notice of proposed action is so important. You tell everybody what you're going to do. They all sign off on it. Then you do what you said you're going to do. But it's important to hit the numbers, right? If you say you're going to spend $54,500, you know, if that's what the estimates come in on, then you're going to say we're going to spend up to $60,000 or maybe $65,000. You don't want to be going back to these people because families don't always get along. All right. They really don't. It doesn't matter if it's in their best interest or not. Sometimes they do things to spite the other and we just don't know why. So those are some of the things that we run across. But earlier I talked about the designations because before you get into this part, if you want to talk with attorneys, you're going to have to speak their language. Deborah mentioned that the administrator it's going to be an administrator or an executor. But you can't even talk to them until the court confirms them and they issue what are called letters of testamentary, right? Well, do you have letters? Have they been recorded? You know, that way the world knows that this person actually has the ability to act on behalf of the estate. Many times people will actually list property. I just dealt with an attorney yesterday that before the trustee was even confirmed, this guy had listed his property for sale with a banker. It's true. Now, he was also a realtor, And this was months ago, right? And he violated many rules and regulations on the MLS, but the property is eventually going to sell. But it could have been so much easier had they just followed the correct procedure and done things the right way. So that's some of the things that go on. Now, anybody have any questions up to this point?
Rick,
If
it's
you have a
Jody. Can I just point out, because this is something that happened in my family, when you're dealing with trusts specifically, the person whose things that it is are not always dead. You may deal with the trust and selling of a home where the person is actually still alive, but you're dealing with trustees and helping them be aware that it's not their money because the person is technically still alive and you are representing the trust. I just thought I would point that out, that they're not always dead.
Right. I'll have Adam deal with that because that is a special case.
Thank you. So what you're referring to is one of the actual benefits of a trust, but that is compared to a will, a trust is operative when signed. Okay. And what you're doing is you're creating a relationship as it pertains to property. And you have somebody who is the beneficiary and has equitable ownership, and somebody who has legal ownership. And the beauty there is the trustee, the person who has legal ownership of real property, bank accounts, what have you, is not necessarily a person. Okay. So when that trustee either loses capacity or passes away, your trust provides somebody else steps in their shoes, and your property is already titled in the name of the trust. So there's just a new trustee. It's that fast. It's a piece of paper. You record an affidavit of change of trustee or affidavit of death of trustee, depending on the circumstances. And that's it. All right. You have a very smooth transition when somebody loses capacity or passes away, as opposed to probate. When somebody passes away, clearly a dead person can't sign a deed, right? They're not selling a property. So that's where the court comes in and they create a court order and eventually letters that gives somebody the authority to act on behalf of that deceased person. But there's months of delay inherent there. Okay. And to your point about trustees, that's really the attorney's job to keep the trustees apprised of their duties and make sure that they're carrying out their duties correctly, because you're right. This is still, we use mom and dad as the example, but it could be a child, it could be a grandparent. This is still mom and dad's stuff until they're gone. Right. And so you all in this room, I'm sure, have seen it. You've got to deal with opportunistic individuals. You have to deal with people that have some expectancy that they start to view these things as their assets and they're really not. And so I would caution you, when you're dealing with somebody, either their parent or somebody is close to death or have recently died, be careful about who your client might be. You may be talking to the, proverbial bad sibling in that family. You don't know. So be careful about who you align with too soon, because you may create a dynamic where your client is never going to have the legal authority to act on behalf of this estate or trust, yet you're aligned with them. So you're gone when the real person gets appointed, right? So you've got to kind of delicately navigate those situations until you learn who's really driving the ship here, because that's who you want to align with, not necessarily the person who you first heard about this estate from. And one really good way to do that is to connect with the attorney, right? If you're asking your what you think is your prospective client, well, who's your attorney? What are you guys doing? If they don't have one, well, certainly they're going to need one, or they don't really have any authority and they're just getting way out over their skis and they think they know what they're talking about and they don't. So you've got to be very careful in how you address that, because we can tell you dozens and dozens of stories of realtors hammering us about, we're going to sell this property. And I say, great, who are you working with? And we go, that's not our client. That's not the trustee. We'll never work with you now because my client's not going to work with someone aligned with their sibling, right? That ship has sailed. So be very careful about that. To build upon the comments about the notice of proposed action, our jobs as the attorneys is to ensure our clients are carrying out their duties and not getting sued, right? We're there because they have a target on their back as a fiduciary. So we're there to protect them. This notice of proposed action is a document that gives beneficiaries a certain amount of time to object. And if they don't, they can never complain later. So to Rick's point about making sure you stay within the confines of that notice of proposed action, if you say, I'm going to sell this house for no less than $1 million, and then your best offer comes in at 950 and your client sells at 950, that notice of proposed action has no legal effect. And now you're exposed, your client's exposed. So it's really important. And these things are really valuable for what we do to make sure that we're creating demarcation lines. Okay, that property got sold. No one can ever complain. That's a done deal. Otherwise, they're going to come in with their own appraiser who's never set foot in the property. And they're going to say, it's worth $1 million more than you sold it for. We're going to sue your client, and all hell breaks loose. So it's really important that these steps are taken in a regimented manner, and you all communicating with the attorney is the way that we keep things on track. Okay. There's nothing worse than us hearing, hey, we're in contract. I'm sorry, what? What do you mean you're in contract? I didn't even know the property was listed. And then now we're trying to go fix things that should have already happened. And that's a recipe for our client ending up potentially sued. So open communication with the attorney is always something that you're going to want to keep. Question.
Yeah, a quick question, maybe I missed it, but a little bit more clarification on exactly who comes first. You as the lawyer or the administrator who gets appointed by the court, and where do we fit in with who do we, I mean, we want to talk to the administrator. I understand that, but who comes first in this sequence of events? Person dies, court gets involved, or do the lawyers get involved, or does somebody step up first? I mean, how does that work out?
These are all great questions. And honestly, it's going to depend on the scenario, but the steps are somebody dies. Let's assume for the sake of this illustration, they have a will. Okay. So they pass away, they have a will. Whoever is nominated as executor in that will is the person who has to move the ball down the field, right? So they would go get an attorney. The attorney would then help them file for probate, and then they get appointed. Until they're appointed, they can't hire you as a realtor, even if they want to. No matter how badly they'd love you to sell this house, they have no legal authority to engage in a contract with you. And so those are the steps. But if you don't have that administrator, executor nominated in a will, well, then it is a little bit of a free for all. And so you guys having connections with the attorneys who may be getting somebody else appointed, a different family member, right? The steps can get a little bit backwards sometimes, to your point, but you just don't want to align yourself too soon. That would be my warning. Yeah.
Deborah, you just mentioned the notice of proposed actions, and I'm just wondering, the question is, when do you send out the notice the proposed actions? Is every step, if there is any change, you're supposed to send it out, or just a one time? I tell you the case that I had. I just closed the Ash Groves, which is a probate, it's a complicated probate, and our attorneys, to my knowledge, and when I obtained the offer and we're signing into a contract, and then the attorney told us that he has to send out a NPA, which is notice of proposed action. But my understanding from Deborah, what you said is you are going to send out the proposed notice, notice of proposed actions along with the listing price, which was established. The listing price could be established when we get a case, like I was signed in January, for instance, but our case was finally cleared by the court, and for instance, it's May. And at that time, you're supposed to send out, because I gave them the listing price proposed by the January. But then in May, when I evaluated it, and I said, we have to justify the price because our real estate market had gone up like 5% to 8%. So to me, and we always want to, sell more to get the maximum. So I proposed, I said that listing price, we give it to you. It is not representative of the current, market. So here is what my current BPL. And then the attorney accepted, our BPL, but didn't say anything. He's going to send out the proposed, notice of proposed actions. Until that we got a contract, he said, hey, you know what, you cannot just accept the contract until I am sending out the notice proposed actions. So everything's being halted at that moment. And so I'm just questioning, how do we coordinate? Is that case by case, or your attorney office by office, or attorneys practice on their own, on their, explanations? I'm just wondering for that.
So my answer really has two parts. The first is I send it as early as possible, but that is dependent on having accurate information. So sometimes I get information from a realtor that we're going to list it at this price and we're doing $30,000 of upgrades, repairs to the property. And I get it all ready to go, send it out. And then I find out, oh, shoot, we found out that there was some problem with the deck. And now it's going to be $75,000 worth of repairs to the property before we actually get it listed. And that changes the listing price. And I don't want to have to send this out twice. So as Rick mentioned, if it's going to be 45,000, let's err on the side of caution and put 60,000, not to exceed, right? Repairs not to exceed 60,000. Soon as we go over that 60,000 number, I need to notify the heirs again. I have to get their approval again. So you want to make the notice of proposed action as broad as possible. It's always okay to sell for more and spend less on your repairs. So be reasonable, be judicious about how you put those numbers in. And if you only have to send it out once, great. We wait our 15 days and then you're free to take your offers.
Building upon that, in our office, we never wait until there's a contract to send out the notice of proposed action, right? Because that's now causing you delay as the realtor and as the seller's agent. So we want to get ahead of that. And we always want to say, we're going to list at X and we will take the best offer over Y. And that becomes our bottom. But if you say, this is the contract we're in and we'd like to send out a notice of proposed action and give you time to object to this specific contract. Well, what if the buyer pulls out? Right now you're back to square one, right? So we want to be firm in our NPAs and make sure that we're not going to be causing any delay.
Yeah, I think that makes sense. And my second question is, whose responsibility for getting client a step-up basis values upon death? In my case, that I was one, go ahead to order that. But I thought that was attorneys when the attorneys take the case, and that's supposed to be ordered by attorney, right? And not me.
Okay, she's referring to upon the death of a client that owns a property. If there's a property in the family, it has a basis for tax purposes. For example, if you purchased a home in Saratoga in 1970 for $200,000 and now it's worth $3.5 million and you've lived there all this time, your basis in that property is $200,000 for capital gains purposes, plus any capital or permanent improvements you might have made during that 53 years you've owned it. Now, when one of the owners passes away, the remaining owner or the trust, if it's the second trustee that's passed away, gets what we call a step up in basis. The IRS says, hey, now you have a new owner. So that whole basis, we're going to say that whatever the value of that property was at the time of death, that becomes the new basis. So if someone dies, say mom died in 2000 and now dad just died and the property's worth 3.5 million, the trust gets a step up in basis. Instead of the $200,000 they paid for the property back in 1970, plus the capital or permanent improvements they made, remodeling, etc. Now that basis will go up to the value of time of death, which is 3.5 million. Your question is, hey, how do we determine that? And the answer is very simple. An appraiser will be able to do that for you without any hesitation at all.
And actually, my question is whose responsibility is between me and the attorney? I mean, attorney is supposed to order it. For instance, in my case, okay, the attorney got that case, which is back to last June. Okay, so upon death, the value, I mean, step up basis of the value is supposed to be established upon the time that attorney took the case. But then when I was involved, and which is, the December or earlier January. So the time that I realized the step up basis of the value has not been established. And then bottom line is I end up, helping the client to order the appraiser to, Rachel appraise.
Right.
But I mean, whose responsibility I want to know. And, is that attorney who take the cases right there? Because sometimes the realtors are being involved much later than you got a case.
So technically it's neither of your responsibility to obtain the appraisal. It's the fiduciaries.
It's a fiduciary. But
Yeah.
what if the client don't have any fiduciaries? I mean, the client is just like, the heirs and they don't know nothing about it. And then they've been appointed as administrator.
Sure. Then it's their duty. And if they're administrators, though, if it's through probate, the probate court will give you an appraisal. right? You go through a probate referee.
Actually, they give a referee's opinion of value.
Yeah, oh, okay.
go through a
So
probate
they got,
referee.
they got from the probate for a referee.
And so you
Okay,
will have
got it,
that. And there are
got it.
certain rules that apply to the sale price having to be what, 90% of the, yeah. Sure. Yeah. So one of the steps in probate, and I think this will tie into what you're asking about, is an inventory and appraisal of all assets. So you have to tell the court, this is everything this person had that is now deceased. And as to any property, it gets valued by what's called a probate referee. They're appointed by the state of California. They have badges, which I think is one of the oddest things ever, but they do. They look like sheriffs. And they're like appraisers, and they just value the property. And then your client as administrator or executor must show the court, I started with X, these transactions took place, we ended with Y. And they need to be able to explain where every penny went for this estate. And then as it ties into sales, like you guys would be involved in, you have to have a recent appraisal. What is it? A year? Minimum a year? 6 months. So within 6 months, you need to have a reappraisal. So if it's taken too long to get to the point of selling a property, you need to go get a reappraisal for sale. And then the property needs to be sold for at least 90% of that appraisal value. And so you can run into all sorts of issues if the probate referee and their appraisal is not aligned with reality, right? Maybe you can't sell a property at all. And so you need to anticipate that as the realtor and say, we're never getting this price. And I think that's happened with us before. We've gone back in.
San Francisco.
Yeah.
They had to go back to the court.
You go back into court and you explain it. You say, there's no way this is going to work. And you have to lean on that probate referee, because otherwise you're stuck within the confines of the probate code to get this done. Trusts, you have a lot more latitude. Trusts are like private sales. They're very easy. You can use a NOPA if you want. You don't have to, but it's effectively a private sale like you would have with any of your other clients. The only thing is you have the added noise of, at the end of the day, you have to answer to beneficiaries, not just your one client. So no matter what you do, you may have to answer them.
Now, let me clarify something for you. The referee's opinion of value is not an appraisal. Okay? Referees' opinions of values can be wildly inaccurate. I've seen them 10, 20, 30% high, 10, 20, 30% low. By the way, they don't even go inside the property. Come on. These are not appraisals. So anytime you want to establish a value at time of death for a stepped up basis, your best bet is you're bulletproof if you explain to your trustee, who's the beneficiary usually, but always trustee and fiduciary are used interchangeably, because they're the ones watching over the estate. If you explain to them, get a licensed appraisal. They're not cheap, but they're worth their weight in gold if 10 years down the road they get audited. Okay. And typically, if somebody dies and then the property is sold within 6 months of death, that usually the IRS will say, yeah, we get that. Whatever it's sold for, that becomes the step up in basis, etc. But if there are ever any questions, always advise them to use an appraiser. Okay, go ahead.
Could you talk about the situations where there is both a trust and a will, and there is a conflict between them? And I'm going to make it more complicated. So there is sole beneficiary who believes the trustee is acting against what is in the will and potentially committing some other misconduct. What could beneficiary do to deal with this type of situation? And this also gets to the question of alignment. That's why I'm asking this question. So beneficiary wants to deal with a situation where she feels her trust is not managed properly and the trustee is ignoring the will.
All right, but before you walk away from the mic, a couple more questions. Is there in fact a will and a probate already open?
I'm not. I don't believe there is. I don't believe probate is open, but
Okay.
there is a trust. There is a will, and let's say that I have seen the documents, and there are some actual facts.
Okay. The will probably would never come into play in this scenario. I thought you were going to get to the point where if somebody forgets to put a house in their trust or a piece of property in their trust, sometimes you can end up with a probate, even though there's really a trust. But you're talking about somebody who is beneficiary and is just not happy with their trustee.
Right, but also let's say the will specifies. Let's say the trust has multiple houses, and will says you can sell this house, but not this house. You have to consult beneficiary before you sell it. This kind of stuff, right? And another kind of trustee is saying, "Hey, I can do whatever I want."
you have a conflict between two documents in that scenario, and that
Exactly.
would probably require court involvement to sort out the settlor's intent, because the court at the probate level, they're trying to carry out a deceased person's intent. So they would have to determine that.
So basically you are saying that the will could override the trust if this goes to court and the court looks at this. So that's what
I'm not saying that,
I'm
but
not saying that you, right. But you're saying that this is a possibility.
it depends on what the court determines the settlor wanted, as determined by the documents and whatever evidence comes in.
Understood. Thank you.
Hello. Just as a scenario that I had an experience, I was just about to close a probate. It was very difficult with some errors. They were defiant. There was 3 sisters. And just as we were waiting for some of the other administrator to go and sign escrow papers, she convinced all the other heirs to object to the sale on the last minute of the last hour. And then it had to go to litigation and for a resale, so it's a horrible experience, but those things do happen.
This was a point we were actually going to address, which is multiple fiduciaries, co-trustees. And this is something for you all to heed as a warning personally in your own lives, parents, grandparents, what have you. Co-trustees are a nightmare. What you end up with is veto power, right? Parents think they're doing the right thing and that their kids are going to just govern by consensus. It doesn't work like that. When it comes to a trust or an estate, every single individual has veto power. You all have to act unanimously or nothing happens. All right. So if you're getting into a scenario where you have multiple fiduciaries, just know everything is going to have to be done in duplicate or triplicate. Every phone call, it becomes an absolute nightmare. And to your point, any one of them at the last second can pull the rug out from everybody else, despite all your hard work. So just be cautious when you're dealing with co-trustees or co-administrators.
I have one of those right now. And by the way, if you want to make things worse, have one of the co-trustees be living in the property. That always makes things worse. Okay. So I have one right now in Los Altos where one of the co-trustees lives in the property. The other one lives across the street. They don't like each other. And there's a small difference of opinion in the value of the property. The one wants to buy the property out. That's fine. You want to live there? Buy me out? Buy me out. Here's the property's price. Oh, well, we don't want to pay that. This will end up making the attorneys probably 60 to 80 billable hours each. Guess who's paying all that money? Oh, isn't the trust paying it? No, they each have their own attorneys. Okay. So it's going to cost all these people a lot of money. They're not going to get along. They're eventually going to settle on a dollar figure at some point, or they're going to sell the property. Of course, one of the attorneys said, no, let's just put it on the market. The trustee that's living at the property now has first right of matching any acceptable offer, and then we're done, which makes total sense. That's the actual value of the property. But of course, that makes sense. So of course, they're not going to go down that road. It'll be a good 40 or 50 more billable hours before they come to that conclusion. This is a problem. Do not have co-trustees. Do not have more than one person making a decision. It is always a nightmare.
Even selection of the realtor.
Oh, it gets very, very strange. I've been involved in so many of those. It's a joke. My mother-in-law, God love her, appointed 2 of her daughters co-trustees. Thankfully, Adam saved the day when he realized that one of the trustees lived in a different state. And oh, by the way, that means the trust will have to fill out income tax returns in that state also, in addition to California. So now we had a bona fide costing reason for one of them to drop out. That really helped. Everything else went smooth, boom, done, gone. But 2 trustees or even more, I've done transactions with co-trustees and 16 heirs that actually went super smooth. I think it was one of Paul's. But I've also done transactions with just 2 co-trustees and they were the heirs. That's it. And they wouldn't be in the same room with one another ever. They both lived in Texas and they flew out on different weeks to meet with me. Go figure. but this is what you get paid for. As the real estate agent, you're the ones that are going to be trying to pull the people together. You're the one that's going to be going, Adam, don't worry. Any issues, problems, or difficulties, what do I tell you? I said, I'll handle it, right? And so I do. And you deal with it and you handle it and you get away with it because it's like, listen, I can't give you legal advice, but let me tell you what's going on real estate wise. Okay. And the reason they listen to us, if you're doing the right thing and you're intelligent and you've given them all the correct data to begin with, they're listening to you because the real estate asset is typically the largest asset in the estate. This is the one where they really want the money from. Okay. It's not the bank account that's got 112,000 in it. Forget that. It's the house in Sunnyvale that we think we can get 3.4 million for, and there's no loan on it. That's where it is. So you've got to get them understanding that you guys don't have to like each other. But if I can convince both of them that my job is to bring in maximum net dollars to the estate, and that's all I want to do is make sure you guys have the maximum amount of money each, then they look at it in a slightly different light. They're going, well, wait a minute. So you're working for me too, even though, yes, as a matter of fact, I am. And so they get that. Not always. And sometimes it's a hard process, but they begin to come around because they want to get maximum dollars. Okay. Question?
Actually, two of them. Let's say the husband and wife are still alive and they have a trust. Can a fiduciary get involved? Let's say the fiduciary is the brother of one of the spouses. Can he influence the trust and have them change certain things?
Didn't we just go through one of those?
What you're referring to is undue influence, right? Which is a concept that basically means overcoming somebody's own volition, right? And you overcome their desires for their estate. To answer your question, yeah, somebody can do that. Just like somebody can break into your home, even though you have locks and you lock all your windows and you lock all your doors. Somebody certainly can do that, but it would expose them potentially to claims of elder abuse, depending on the age of the person on the other side of the influence. It could be a void transaction, depending what happens, void trusts, void wills. But yeah, we see this stuff all the time. That's why we have jobs, frankly, is that it is a very fine line between what is persuasion and what is undue influence, right? Is saying, hey, I'm a deadbeat, but my brother's a doctor, therefore I need the money more than him. Is that undue influence or is that reality? I don't know. It's going to be for a judge to decide depending on mom or dad's condition at the time.
Well, I'm talking about a fiduciary. I guess the fiduciary is not related to the deceit.
Are they already a fiduciary?
Yes, but they're let's say husband and wife, they have children, and the fiduciary is the person who administers the trust at the end, right?
Right. But what I'm asking,
The
are
fiduciary,
they trustee now, or are they just going to be someday?
yeah, they're going to be the fiduciary after the death.
Okay. So they don't have any role.
And if and let's say that he's a brother of one of the decedents.
But what's the question?
My question is, can he influence the owners while they're alive to make changes to the trust?
Yeah. Yeah. I mean, I wouldn't give him permission to. Can he? Yeah, he can. It
And
may
let's say-
give rise to claims.
Right. And let's say he does, and they change the trust, and one of the heirs, let's say, gets cut off the trust. What happens then?
It depends. That heir may have some legal rights. They may have claims. It's going to depend largely on the circumstances, because people are allowed to disinherit people. And you have to get into the weeds on the facts of whether or not it was appropriate under that specific set of circumstances.
Got it. My other question was, so there's a trust, and and the owners own it as community property. You can?
Go on. No, go on.
ahead.
No, you're good. Go ahead.
So there's a trust with the community, the owner's husband and wife owns that as a community property. The first one dies. Is there a step-up basis at that point?
Yes.
And then this,
Full
Okay.
step up.
well, okay.
Yeah. Community property, you get a full step up in basis. Joint tenancy property, on the other hand, 50% step up in basis. And then you've got to go convince the IRS to get a full step up based on a community property theory. But yes, to answer your question.
There more
Next.
questions?
Couple questions. First one
Get
happened,
really close to the mic.
oh, okay.
Thank you.
The first one happened about 10 years ago, and we had a family that had 4 boys, okay? And according to the agent, he says the owner is dying in the hospital, and he had several properties that he was getting rid of, and this was his last one that he has to sell. And he says that one of his sons are very greedy. The other one is very peacemaker. Another one is just, business person. And, so there are four different personality, but the owner decided to take the greedy one off the, as a joint, where the 3 of them are it's not beneficiary. What do you call them? The heirs, yes, but they're all 4 are heirs, but the 3 are trustees, they're co-trustee, okay? And like you said, it is a nightmare when you have more than one person, okay? And in this situation, the agent ended up being a notary. I was very lucky because I sold my client's property already, the condo. And he says, don't worry, I got your back. I didn't know what that meant. And then 3 days before the close of escrow, he calls me and says, oh, sorry, the person passed away. And he says, but I got your back. I told you I got your back. I didn't know what it meant. He says, I got them notarized before he died. So does that mean that the 3 boys had given their right to one person to sign on their behalf? Is that what you think happened? Because they didn't agree to each other, always fighting with each other. So that's one of the questions I have to ask you. And then I don't know how he pulled that off.
On that particular question,
Mhm.
it sounds like the fellow that died was still entitled to the property. In other words, he wasn't dead yet. So
He
the
was the
property
father.
was still owned by the trust.
Uh-huh.
That was the father, right?
Yeah.
The father owns the property. Property is put in the trust. Guess who the signer is, the trustee for that property? It's still the father until they pass away. The other trustees don't become trustees until the death of the main trustor. Okay,
Oh, that's how they pulled
There-
it off.
So,
Okay, 'cause I couldn't
so
figure
if
out.
he signed off prior to actually, I mean, there may be a case for competency, but if he signed off the closing documents prior to his death as the trustee of the trust, that would be, not considering undue influence or anything like that. That would be legal and functional.
Oh, that's how he did it. Because I remembered when we asked for something, we asked for a $10,000 credit, and he held on to that purchase agreement. Even to this day, I remember. He says, please don't ask for anything else. This is the last thing we want to give you, because he can't even lift the finger to sign this, addendum or whatever. And so I realized that, we're very fortunate. And the thing about this situation, now I know what happened, okay, that he signed before the probate. I mean, before he passed away, so it didn't have to go into that. The second question is there a difference between if somebody passed away and it was in a trust versus an LLC? Can you tell us the legal, aspects of both? If somebody passed away and their property is in a trust or an LLC?
Sure,
rental
I can
property?
explain that. If you'll allow me to just skirt the question for just 1 minute. When a person owns property, as Adam mentioned earlier, a trust is a relationship between a person and their property. And we can define what the property is, who the manager of the property is, and who gets to benefit from that property. And so it is entirely dependent on the person who created that trust to fund the trust, to actually put the assets into the trust. And they can put assets in lots of different places, right? We can create assets that we call non-probate assets, like 401ks, life insurance that pass by beneficiary designation. We can designate specific properties to go into the trust and other properties not to be in a trust. And we can buy properties and put them in LLCs. And each one of those forms a different relationship with the property. So an LLC is going to be governed by the operating agreement of the LLC. So depending on who has control of that LLC when a person passes away, if that LLC is assigned into the trust, then the trustee will be able to, within the terms of the operating agreement, there may be other LLC members out there who are managing that LLC property, but assuming it's a single member LLC, they'll be able to manage that LLC property. So it really depends on the operating agreement of the LLC.
So you recommend for people that own properties that are rental properties to put their rentals in an LLC and then put the LLC into the trust? Is that what you're recommending?
I can't recommend that as a blanket statement, but
Okay.
I'd say in many circumstances, that's, if it's a rental property, it's certainly something to consider. I would recommend that they meet with an attorney to make sure it's the right situation for them.
Now, we heard that in Montana, if people look into your assets, they cannot see what you have. I don't know if it's true or false, but when you put your assets into a Montana trust or LLC, they will not be able to see what you have. I don't know if it applies in Florida too, if there's a Florida trust, or Delaware, but that's what I heard, but I could be mistaken. So can you tell us if it's a California property, can you put it in is it called LLC or a trust that you would open up in Montana?
You can have properties owned by LLCs that are foreign LLCs. You'd have to be very careful about why you're choosing that and what the actual upside is. I can't speak to Montana LLCs. I can tell you I have a property in Montana. There's something called Montana Cadastral, where you can look up every owner of every piece of property in the state. So they actually have more transparency than most states I know as it pertains to LLCs, only because I actually got annoyed with one of my neighbors and was curious who really owned the property. You can find them. I was able to, and that was through like 3 or 4 layers of LLCs. So at some point the buck has to stop. And
So it's not true that.
it
you
may
cannot
be
see them.
anonymous at level 1, but if you keep digging,
You'll
at the end
find
of the
them
day, you can probably find somebody.
Even in
Yeah.
Montana.
But
or
again,
Delaware.
You got to think about what's the goal, right? LLCs can be sued. It doesn't necessarily matter.
But it's just.
who
like,
the
you
owner
want
is at
them
the
to
end of the
see what
day.
You have is what I'm trying to say. Is there a state where we can open an LLC or a trust where they cannot see it by state law? I don't know.
I wouldn't know from a state by state basis. I wouldn't know, but just LLCs on their face are pretty anonymous,
Yes,
right?
of course. They can't see it.
If
unless
you
they
have the
put it-
agent for service of process as a third party,
Yes.
then it's already fairly anonymous to begin with. But I can also go back into chain of title and see what you used to own, even if you put it in an anonymous LLC.
Oh, I see. You
Right.
can see the chain of title. So eventually you will see it if you dig hard enough.
Right.
Okay, got it. Thank you.
In the end of the day, it's hard to lose a recorded document. It's hard to hide them so that you can't find them. Now, before we get to the next question, let me pop a few items here into you. If you're thinking of getting into working with attorneys, selling property that's in probate or in trust, there's a couple of things that you need to be aware of. These can be messy, all right? When I'm called in, typically it's because, well, mom died 8 years ago and dad just passed away. Okay, so let's meet at the property. And you walk into the property and sometimes the property's in reasonably functional, good condition. Okay. Never. It's not usually so sharp. Okay. And there's a tremendous amount of personal property. So when you're working as a real estate agent or broker and attempting to help attorneys and bringing something to the table that has value to the attorneys and their clients, another thing you need to consider working with is an estate planner or organizer that actually comes in and takes care of what's left behind. You know, much of what is there has very little value. I understand it's their entire life, right? The furniture, the belongings. You walk into any house and you see absolutely everything that's there. And if we don't look in drawers and closets as we're showing property, but when it's the estate, the kids are there and they're looking, wow, I've got to get rid of all the clothing. I've got to get rid of everything in the garage. I've got to get rid of all the tools. I've got to get rid of the vehicles. I've got to get rid of that boat that leaked that dad never, ever used since 1923. I've got to get rid of everything. It's like, well, what about what's in the attic? Oh, I forgot about the attic. I got to get rid of everything there. So if you're going to be part of the solution, you need to be bringing some solutions to the table in that particular arena, because guess what? You're not going to be selling the house until it gets cleaned up. And you're not going to be closing escrow until all of the personal property has been removed from that subject property. Does that make sense? So learning and getting in touch with some estate planning organizers, and you can Google that. There are many that work throughout the area here. I've worked with 5 or 6 of them over the years. You're going to find out what they can do. They do charge money. Sometimes I'll go to an estate and the only person I have to call is the hauler. Sorry, that's what happens. You know, I mean, that's just what takes place sometimes. Other times I need to bring in not only an estate organizer, but I need to bring in maybe a rare book appraiser for first editions. I need to bring in maybe a museum appraiser for certain pieces of art or sculptures, because these have value. You know, these are things that you need to be able to bring. You're not going to tell them what to do, but if you can bring them some solutions, because these people are, what are they? First of all, they're the trustee. They're responsible, and they've got probably 2 or 3 other people chirping in their ear about value. They want to get their money as soon as possible. They've got the responsibility if they're a single trustee. They don't want to do something wrong. They don't want to sell that painting on the wall for $100 if it would really sell for $5,000. You follow what I'm saying? So you need to be having resources of this nature in order to actually offer a full service that comes with what you do as a real estate professional when you're selling a property. You don't get to just sell the house. Okay. It's very unlikely. I don't remember the last, actually, I had a recent one that the trustee, you know, I met with him there. The trustee was older than the decedent because the decedent didn't trust his son. So I meet with him and he goes, everything's cleaned up. We're all good to go. All I got to do is get rid of that car and these few things here. I bring in the estate company, you know, 8 days later, everything's gone. We sell the house. Everything was good. Very clean and normal. We didn't do anything to the property. Didn't even have to paint it. That's very rare. Usually once everything's out, it's like, oh, we got to work on this. You know, it's like, you know, look, the throw rugs are gone. I say, yeah, isn't that great? It's hardwood flooring. I said, well, it used to be. You know, we have to refinish it, you know, or it's like now everything's off the wall. It's like, yeah, how come there's all those shadows? Those aren't shadows. It hasn't been painted since 2002. Okay. We have to repaint. So these are services that if you're going to get involved in this type of business, you need to start thinking about, because you're going to need to have people that can do that for you. You don't have to do it, but you need to have resources to pass on to the trustees so you can be helping. Okay, because the person that they're likely to hire first after the attorney is probably going to be a real estate broker if there's property in the trust or if it's in probate. So those are some things to think about. Yes.
So just a quick anecdote building upon what Rick just said. That's hugely valuable. If the realtors are bringing in resources like that and taking that off of the attorney's shoulders, because we don't want to be dealing with personal property either. But there is a certain sentimental value that people subscribe to property, right or wrong, and it can create massive issues. So to give you an idea of the craziness you'll get to deal with in this area as you move forward, I once had a case where we were getting down to the end. It was different factions, right? A second marriage. So you had stepchildren, but they were like in their 60s. These were not children. And the last thing to sort out that nobody could agree on was what to do with 100 paintings, give or take, in this home. And so, oh my gosh, all right, we had to go hire somebody to itemize all the paintings, and I'm talking to the clients about what they think they might be worth. These were paintings painted by mom and dad. They had literally no value. And we got to the eve of trial and settled this case maybe at midnight, 12:30, the night before trial. We were going to go to trial about who gets mom and dad's paintings. Not that they're worthless, but my God, they have no value, at least not monetarily. So that's a situation where I would have loved for somebody to bring in a third party to help negotiate all of that and keep it out of the attorney's hair. And those are massive resources for us. Yes.
What Rick just said is true, because I have a friend going through it. He doesn't have a brother. His brother passed away many years ago, but the mom left a lot of stuff that he has to sort and clear out. Anyways, my other question was, husband and wife own a property in a trust. One of the spouses passes away. Now, can the surviving spouse change the terms of the trust if the trust is a regular trust, or if the and it's an irrevocable trust.
I'll give you the lawyer answer. It depends. It sounds like you're describing an AB trust, which is where you split the trust into two when somebody dies.
No, no, no. What I'm saying is two scenarios. One of the spouses passes away. Now the surviving spouse has a trust, and it's a regular trust. Okay. Can she change the terms of the trust?
It will depend 100% on what that trust says,
Okay.
because some say this trust remains revocable after one of us dies. Some say half of the trust remains revocable after one of us dies. Some say this entire trust becomes irrevocable when one of us dies. It will just depend on what that trust
Okay.
says.
So if it's irrevocable, nothing can be changed.
I'm not gonna go that far.
Okay.
It depends. I will say this: if you guys ever want to be a hero and you're selling a property and you see family trust or bypass trust or that kind of language, talk to your client or have them reach out to an attorney, because there could be massive tax implications selling from a bypass trust or a family trust, because you lose a step up in basis.
Oh, wait, didn't we do that?
Yeah, we do it all the time. So we'll go in. We did it for your mother-in-law. That's right. That's right. Yeah. So what happens when a first spouse dies in an AB trust situation is, I'm speaking in broad swaths here, but you divide the assets 50-50, husband's half, wife's half. And the value or cost basis set for the first spouse to die's property is set as of their date of death. Well, if their spouse outlives them by 10, 20, 30 years, there is a lot of appreciation sitting there in those assets in that trust that is going to be taxable. And so there are some mechanisms where we can go into court, we can get a court order that basically wipes out that trust, dumps everything into the survivor's trust, and now you get a step up as to the second spouse's date of death. And this can be, multiple six figures of tax savings depending on the scenarios. And we've had great success at that. So if you guys see those terms, just think of that as like a trigger to say, hey, you should probably go talk to your lawyer and see if maybe there's something that could be done here. Bypass trust, family trust, survivor's trust, good, right? We always want survivor's trust. Exemption trust. What was the other one? Disclaimer. Well, I don't know if you could terminate a disclaimer trust. That's a good question, because you've already disclaimed. Probably not, but those are the big ones: bypass, exemption, B trust.
I just have a quick question. Let's say you've got, the property was in a trust. You're the executor of that trust. And you move it from that trust into your own personal trust. Is there, I mean, do you lose any tax implications? Does it change the basis any by doing that?
Yeah. What you're describing, I don't think it's what you mean, but what you're describing doesn't track legally, right? And I know it's not the way you meant to say it, but it sounds like you just stole that property from someone else's trust and put it in your trust. Are you saying you inherited it from somebody else's trust? Okay.
Sorry.
All right. If you inherit it, there's going to be a deed from that trust to you as beneficiary and then into your trust. So that'll be the chain of title. But that was a good question. You don't take it from trust, mom and dad trust, to child trust directly. You want to have an intervening deed.
No, it was all moved through. I had to go and petition for it and make that all move, but I'll talk to my.
It doesn't change the tax ramifications to your point. There's no tax change or no implication by you having done that.
Speaking of tax issues, okay, prior to Proposition 19 being passed, there was a circumstance where when you inherited income property, multiple units, rental properties of any kind, you were still able to keep the property tax assessment if it was a parent to child transfer, and oftentimes from a grandparent to a child transfer. You can no longer do that. Be aware that if you're dealing in these scenarios, once the property's owner has passed away, if they have investment property in California, it is reassessed as of the date of death. Now, that doesn't necessarily mean you're going to get a bill, okay? It means that it's going to be reassessed and you're going to get a bill. Now, if you're dealing with the trust and you've sold the property, well, that's all well and good, but bear in mind, there's still a bill coming. Okay, you have to understand, and the attorneys will always advise their clients, whoa, wait a minute. Don't get rid of all the money in the trust. Okay. Well, no, there's 100,000 left. Why don't we just keep 5 in there? Say, well, have all the bills come in? What bills? Oh, there's bills. Okay. And if you have investment properties, they will reassess it based on the value of the property at time of death. And that's where the property taxes will go to. I just did one in Belmont. Okay. And so I had to I just said, okay, assuming that what we sold it for was the value. And I thought, wait a minute, date of death was way before that. I did an analysis for the property at date of death. I said, well, it's going to be worth a little bit more. And so I figured at 1.25%, what could they come back at us with, right? And so that money had to be left within the trust. And then eventually that trustee will get a bill from San Mateo County saying, oh yeah, we reassessed that property. You know, they don't care if you sold it. For the time that you owned it between the date of death until you closed escrow, the property taxes went through the roof. So you owe that difference. So those are some things that happen with Prop 19. Kind of a big deal. Also, a lot of people think you've got 4 heirs. They think, oh, this is great. I'll just buy my other heirs out because mom's, it's a $2.5 million property, but mom's assessed value is 102,000. So I'm going to get to pay, you know, almost nothing in property taxes. Well, that's not going to happen. Okay. What happens is they've inherited how much of it if there's 4 of them? They got 25%. So 75% of that property is going to be reassessed. Ouch. So instead of property taxes of $1,230 a year, they're going to be paying $1,500 a month or something like that. So these are some things that happen. You have to be aware. And dealing with trustees and heirs where someone wants to buy someone else out are the hardest transactions I've ever done. You can try to refinance them out. I've pulled it off 3 times, all with the same lender. I don't know if you ever did business with Terry Garfing. Anyway, okay. And we got so lucky. I mean, it was just mind-boggling, but it requires an incredible lender. It requires complete trust from all the heirs, and it usually goes sideways anyway. So when someone's trying to buy someone else out, it's usually very, very difficult if they want to remain in the property and do that. Hence the one I told you about earlier. It's going to be months before these people figure this out. I mean, might not even be this year. That's just the way it is. Personalities play a big role, and your job, if you choose to go down this road and get involved with this, your ability to deal with the different personalities, taking a burden off the attorneys, is going to be a big thing to the attorneys. Wouldn't you agree? I mean, if they just say, well, wait a minute, you know, did you talk to Rick about that? And they say, well, no, I should call Rick. And then they talk to me, and then they don't call them back. Yeah, they go to bed thinking Rick did good. So these are the kinds of things that you bring to the table if you're successful. And these are the kind of actions that don't pay commissions to you directly, but these are the kind of things that if you do them, will end up getting you more business from those particular attorneys. You have a question?
Substitution of attorney. When the PR files it, does the probate process start all over again? Or does it continue from the date that the PR files substitution of attorney?
All right. You're saying substitution of attorney.
Yeah, the PR has an attorney, and
Okay.
for whatever reason, the attorney's not, you know, contacting the PR, the PR is not getting an answer from the attorney. So the PR files substitution of attorney, and now they want to do it as improper.
Okay, there you go.
That's
That's where I was confused.
Okay.
Okay, so PR is personal representative, administrator, executor, et cetera. So what you're saying is you basically want to fire the attorney and move on without them.
The PR, yes.
Yeah. And the personal representative continues, the probate continues to march along. In pro per is basically you represent yourself. And certainly that probate would continue to march along. It wouldn't impact the probate. No.
Okay.
I just want to mention this. I don't want to get in the weeds, but I do want to, what we've talked about in probate is when your personal representative has full authority under IAEA. There are times when the representative will not have full authority, and that means that every step of the process, listing the property, everything has to be court approved. And once an offer is accepted, that offer will not go through until it goes to court for an auction, right? And so at an auction, anybody can come and overbid, and literally as the attorney, we have to stand there and host a bid for anybody else. And we also have to publish notice. So we have to publish notice in the newspaper that this house will be auctioned off in court on such and such a date at such and such a time. And so my buyer and my buyer's agent and my personal representative and their agent all appear in court, and we wait. And if we have to, and a new bid comes in at a higher price, there's a whole process for outbidding each other. The agents will have to step aside, make sure that the person actually qualifies, all of that sort of stuff. So it's a little more complicated. So just pay attention to whether you're in the letters of administration that you see for your client, whether they have full authority or not.
He was asking about the probate disclosure. Actually, we have a probate addendum now. Okay. The paperwork related to trusts and probates is on your CAR library. And if you have any questions or concerns about that, talk to your broker. Okay. The probate disclosure basically has all that information in it. And there is a box that you check to let everybody know, hey, do we have to go to court? And the answer is usually no, but maybe you do. Okay, so you have to check the appropriate box. And when you do go to court and there is the overbid process, I've been to several of these in several different counties. And let me explain who has final authority. The judge. Okay, I've been there representing the buyer and the seller in probate court when another offer came in that was higher than the offer that this particular buyer was willing to pay. And the judge signaled me to come up and he said, where do you stand on your transaction? I said, Your Honor, we can sign off tomorrow and close in 3 days. And then he brought the buyer up and said, what about you? He goes, well, I haven't got a loan. I have to go out and get a loan. I can put 25% down though. Case closed. He threw him out, even though it was more money to the estate, and said, no, these guys are closing escrow in 3 days. He issued an order that we had to close within 10. We did, done. So it differs. Okay. And by the way, first of all, this is very rare. You don't see this almost ever anymore. In fact, I was at a proceeding in Santa Rosa on a probate where the judge came in and said, you know what? And by the way, probate courts rotate. How often do the judges sit in probate?
3 years max, 2 to that.
So 2 to 3 years. So they're not if they've just come in, they're not experts, and they rely on Jonathan here. They rely on the probate attorney who is hired by the county, who's sitting in at all the court proceedings. Like, what's going on with this, and our Santa Clara County probate attorney happens to be a fellow by the name of Jonathan Kahn, who used to work with Adam. And so these are things that it's not always cut and dried, and the judge does not always know absolutely positively everything. If they were seated in January and the court and they're hearing this case in the late part of that same month, they may not know the answer, so they'll rely on other things. But that's how those things go. It can be very strange. And then there's an overbid process. The first overbid is determined by it's $500 plus 5%. And then from there, the judge will determine the next steps. Okay. So that's how those typically work, but it's very rare. I think that was it. Yeah.
It's to be avoided.
At all costs. At all costs. Yeah. We've got 3 minutes left. I don't know. Any other things you guys want to hear about rather than specific stuff? Would you like to hear anything more about doing this actual business? Oh, that's a great question. Yes.
I would say at least check in with the attorney every 2 to 3 years. And one of the things we're checking for when somebody comes in with the trust is I look at their schedule of assets and then I check the deeds to make sure the deeds match. Oftentimes people will believe that they have their house in a trust when in fact they don't have their house in the trust. It's great if it's listed in the schedule of assets. We have a process that we can go to the courts for to get that moved into the trust. But if it's not on the schedule of assets, I have a case right now where I have a client who created a trust in the 1980s, never revisited it, sold the house that was in the trust and bought a new house in the name of he and his wife as community property. It's outside of the trust and I don't have any way to get it in. So we're probating a property that really should have been in a trust.
And I know that this is not the case with the people sitting up here, but sometimes attorneys make errors. I had a transaction once where we were about to put the property on the market for $850,000. I got a preliminary title report and I noticed that the legal description of the property that was in the trust did not match the preliminary title report. So we got involved with the title company and this was with this was with an attorney who has a trust center in Southern California, but a local office at the airport in the city of San Jose. Hint, local attorneys are better. All right. To his credit, though, he did not draft that trust and he did not draft the legal description of the property. There were 3 properties in it. The other 2 had been sold while mom was still alive because they had. Yes, you can go ahead and sell those. Each daughter could, but mom corrected the problem because mom was alive. So we went and said, how do we correct this problem, guys? I said, no problem. Just get the trustee in here and we'll get her to sign an affidavit. So yeah, she passed away 2 months ago. Not going to help. 18 months in court. Why 18 months in court? Well, we went to the right place. We said, okay, let's go to the attorney who drafted it. Sorry, he's been disbarred. Okay, well, how about this is what happens. Well, then good, let's get the attorney that bought the practice. Nobody would touch the practice. So after 18 months in court, we got it.